Hi there, my name is Dr. Iyan Offor, and I'm a lecturer at Birmingham City University. And I'm going to be presenting some early results from collaborative research that I've done with my colleague at the Strathclyde Centre for Environmental Law and Governance. His name is Dr. Antonio Cardessa Salzman. So we've been researching this idea of multi-species lawscapes in the Anthropocene. So I'll talk through what all of these things mean and could do for us as animal lawyers. Personally, I work on the interface between animal and environmental law, and I'm really interested in the ways in which the constitutional turn in environmental law studies that we're seeing right now, whether that could resolve or potentially perpetuate the way that non-human animals have often been absent reference within environmental law scholarship. They've been fairly invisible in a lot of that scholarship as individuals. So together with my colleague, Dr. Cardessa Salzman, I've been researching how law can evolve to respond to the context of the Anthropocene in a way that prioritizes multi-species approaches to law. We believe that law should take a multi-species turn if we're to have any hope of getting through the Anthropocene in good shape. We also believe that we must fundamentally reconsider the role of law in our societies in response to the emergencies of the Anthropocene. So in terms of the structure of my presentation today, I will first briefly set out the current context for our research by introducing concepts of the Anthropocene, its related planetary boundaries, and planetary justice. Then I'll go on to describe our work to spot trends within existing critical environmental scholarship. That's some of the key research results I'll be sharing today. And finally, I'll detail our ideas on multi-species boundaries, noting that we've also worked on societal boundaries, but there's limited scope to discuss that here today. So we're focusing on the multi-species boundaries element of our research. So starting off with our concepts and beginning with the Anthropocene, really important one for our research. So what is the Anthropocene? It is a new geological epoch which follows the Holocene. And in this new geological epoch, we're finding that humankind's actions are the dominant impact on climate and our environment. From a multi-species perspective, it's apt to question the anthropocentricity, the Eurocentricity, and androcentricity of the Anthropocene concept itself. Donna Haraway, of course, has proposed the Catholocene as an alternative, which emphasizes efforts towards making kin and working towards symbiotic connectivity in our law. The Capitalocene has also been proposed as another alternative. So the Anthropocene isn't the only intellectual tool available to think through this new age that we're finding ourselves in. So what about the planetary boundaries framework, which is kind of inherently linked to this idea of the Anthropocene? The planetary boundaries framework defines a safe operating space for humanity on Earth. And note that that's just for humanity, not other forms of life on Earth. I'm pretty interested in the fact that at this moment in time where we're ostensibly moving forward in terms of our thinking regarding other species and the impact of humans on our Earth, we're retaining this focus on humanity's safety in some of our foundational concepts, like the planetary boundaries framework. And we're completely disregarding in that way the safety and lives of other forms of life on Earth. So what use then is this concept for the Anthropocene if it retains this anthropocentricity in its very ethos and culture? That's a conceptual point that we want to contest. You may know that when the planetary boundaries framework was first proposed in 2009, 4 of those boundaries had already been breached, and now a 5th boundary has been breached. And I wonder how many more would exist and would have been breached if safety were conceptualized in a more multi-species way. So the slide here depicts the ways in which some of these core planetary functions and boundaries have been breached in recent years. So how should law respond to this situation? Well, we see a growing trend in critical scholarship that is recommending a move toward post-humanist, systems-oriented, and ecocentric approaches to law. This would radically reformulate our onto-epistemological and material ideas about what law is, as well as how law works and, crucially, who it works for. So in our work, in our research, we aim to elaborate on this scholarship, this emerging critical scholarship, by identifying key normative priorities for multi-species law and governance in the Anthropocene. And in particular, we're looking for ways to decenter humans in legal systems and human ways of doing things. Even more specifically, we're interested in what Kuhn and Jefferson have called ecocentric post-humanist legal imaginaries. It's a fair amount to sink your teeth into there. But we want to incorporate deep listening to the insights and the priorities of marginalized human actors and groups, as well as non-human animals and non-living nature, in this new form of multi-species governance that we're talking about. In particular, we've commenced by looking at building on literature on planetary justice. Planetary justice is identified and defined by Dreiser and Pickering, and they set out some key concepts for this new kind of justice in the Anthropocene that we wish to build on. We want to expand, or rather the planetary justice concept expands the idea of justice beyond the state to include non-humans, future generations, and the Earth system as a whole. It works to overcome the human nature divide. And we feel that we need to use both individual and collective approaches in order to do this. That's a core part of the planetary justice framework as well. Planetary justice also requires questioning this narrative of endless economic growth, identifying that as a fiction that is not capable of coming to fruition in reality. And there's also a focus within planetary justice on the participation of people in shaping just solutions. Beyond this, beyond these kind of core normative contents for planetary justice, the rest of it remains an open question. So we're interested in playing with this concept in our research and seeing what scope there is for attaching multi-species boundaries to this idea of planetary justice, because we think it could help move us in the right direction. Am I on the right slide anymore? No, I'm sorry, I'm behind on the slide. So this was the idea of planetary justice and the points I've just talked through. Moving on then, to talk about some emerging themes in the literature on Anthropocene governance. And this is where our research has come in, where we have started to trend spot themes that are existing at the moment in ecocentric legal scholarly spaces. In particular, those that we think could support a move toward multi-species approaches. In doing this trend spotting work, we reviewed research on Earth jurisprudence, Earth system law, ecofeminism, planetary justice, and wild law. Of course, there were other areas that we could look at, but this was a scope that we determined for ourselves to begin with. In doing this research, this trend spotting, we identified 2 problematic trends, and afterwards I'll share with you 5 trends that we identified that might actually help us flesh out better multi-species Anthropocene governance. But starting with the two problematic trends. First of all, we see ideological closeness in ideas proliferating in many of the areas that I just listed that we focused on. But we noticed that these research areas are disconnected. They're not being linked together in a way that could be fruitful. So we tried to start working as a connector between these different areas in our research. The second problematic trend that we identified is a trend emerging that favors overarching, totalitizing, and all-encompassing normative frameworks. So universal approaches to the problems of the Anthropocene. And this has been proposed as a means of thinking about political institutions and legal instruments as ways to deal with the emergencies of the Anthropocene. And we see this in particular in research emerging in Earth system law. However, and productively, we're seeing critical scholars like Marie Catherine Petersman and Anna Greer arguing against this kind of overarching or totalitizing sort of regime or set of instruments to deal with the problems of the Anthropocene. We tend to find this globalizing approach to disproportionately impact marginalized communities in a negative way. And those are both human and other marginalized communities. We find that their interests often get lost or obscured within these so-called global approaches, which are perhaps not very global at all, but are often just upscaling Western approaches to dealing with certain legal issues. Okay, moving on then to the 5 productive or useful trends that we identified in the literature. We found 5 trends that are orbiting this idea of, or future vision that we see of an interconnective, symbiotic, and symbiotic lifelong governance. This is these are some of the goals that we are looking for in pursuing a multi-species kind of governance for the Anthropocene. So first of all, two of these goals are shared by the Earth system law approaches that I mentioned as being slightly more totalitarian in approach. So those two trends are the first two listed on the slide here. There's a growing recognition of the significance of networks for environmental governance. So rather than looking at individuals, looking at networks in between individuals and communities. And in addition to that, there's a preference for ontologies and epistemologies that reject dualisms or binaries in favor of spectrums emerging in the research. So this could be relating to anything like the nature-culture binary or the human-animal binary. There's a growing preference for nuancing those binaries and those ideas and seeing a spectrum instead, with various points along those spectrums being possible. Then, so moving away from those two trends that we saw that existed within Earth system law research and other critical research, we then identified three trends emerging from these other areas of research that I mentioned that kind of resist or grow away from the Earth system law research that's emerging. The first of these is plurality. This is the idea that law and even cosmologies can coexist. And the idea of Western universalism being identified as just one idea amongst various alternatives. So this totalitizing approach, this idea that we can come to one global universalizable solution to a global problem, identifying that as maybe just one option amongst others. So plurality was the first resistant trend that we noticed, moving away from Earth system law. The second trend that we noticed is a growing preference for dispersing power and focusing on the interconnections between legislators and governing bodies, as opposed to top-down unified governance. Now, obviously, that relates to the trend of thinking of alternatives to plurality. Dispersed power kind of goes along with that. And then finally, we've seen in the literature a growing recognition of the power structures that undergird systems of oppression amongst human and non-human communities. So the intersectionality of different kinds of oppression. And again, that's somewhat moved away or moved beyond what Earth system law is talking about at the moment. So all in all, we've seen these interesting trends emerging out of the literature. These are some of the key trends that we've seen come up a number of times in these different areas of literature. And we think these could be useful ideas or normative insights for thinking through a multi-species kind of governance for the Anthropocene. So in addition, as I mentioned, to working on the connection of planetary justice with societal boundaries, which I won't cover in this presentation, my colleague and I wanted to explore what direction these 5 trends could take us in when thinking of evolving ideas around planetary justice and multi-species boundaries. We wanted to react to how non-human animals have been treated as absent reference within ecocentric environmental law scholarship. And for example, by focusing on one interconnected Earth system, we often make the inability of individual animals to flourish within that system invisible. That's one of the ways in which animals have been treated as absent reference, to use Carol J. Adams' term, within ecocentric environmental law scholarship. So the first question for us was, what precedent already exists for bringing non-human animals into this discourse on the Anthropocene and planetary justice? First of all, here, we saw increasing overlap between, for example, rights for nature and animal rights discourse. One example being Angie Pepper's work writing about how non-human animals experience disproportionate adaptation struggles in the face of climate change. That's just one of a number of examples of these two areas coming together more and more. Second, critical animal law studies, we found, already incorporate many of the themes that we just identified, that we've seen in this critical environmental scholarship. So there's a possibility for synergy there. So for example, the idea of binaries. There's a frequent rejection of the human-animal binary in critical animal studies. So for example, Megan Glick's work on infrahumanisms, which regards the human as a historical production. And she raises the idea of liminal subjectivity, so kind of blurring that harsh divide between human and animal. Another example where these concepts or norms have filtered into both areas is with regard to plurality and power dispersion. So as an example, Donaldson and Kimlicka argue that we should not use claims of universality for animal rights in a way that justifies instrumentalizing those rights as an oppressive tool. So that idea of thinking about plurality, different modes of governance, and dispersing power rather than thinking of one universal or global approach already exists in animal law studies and critical animal studies. And then increasingly, we're also seeing considerations of intersectionality in animal law and critical animal studies as well. So for example, Black vegan studies and critical race or critical posthumanist studies are recognizing animality as a raced concept. And that has this research has a lot to say about the intersectionality of these different kinds of oppression. Okay, so moving on then. In our work, we begin thinking about what it might look like to bring animals into this kind of Anthropocene governance, to move away from animals being an absent referent, particularly when talking about environmental governance, but more broader governance and law in the Anthropocene as well. So we believe that Anthropocene governance requires broad and diverse participation, and that links to our work on societal boundaries. And we argue that the processes of democratic decision-making cannot be anthropocentric, androcentric, or ethnocentric. So this means bringing animals in. For a specifically multi-species approach, this created two priorities for us, which focus on decentering the human in our governance and policymaking. These are deep listening, that's our first priority, in order to identify what could be referred to as multi-species boundaries. Our second priority is to identify or talk about agential force. So finding ways to act on the multi-species boundaries we identify by looking at what kinds of agents have, what kind of actors or actants have the sort of force that an agent has, whether that's a moral agent or a political agent or something else. So let's start with deep listening before we come on to agential force. In terms of deep listening, there's lots of literature about this within critical animal studies and some critical animal law studies work as well. McKinnon and Donovan, very prolific feminist animal studies scholars, have talked about how the solution to animals' problems should be their own. We should be listening to what they have to say. Sarah Colling tells us that we should pay attention to how animals resist the horrors we impose on them. And Josephine Donovan, writing individually, uses this quote that I really like, where she says that we should not kill, eat, torture, or exploit animals because they do not want to be so treated, and we know that. If we listen, we can hear them. So what's coming out clearly here is that feminist ethics of care are a useful choice for modeling this kind of listening. McKinnon and Donovan write about feminist ethics of care and have some clear ways in which we can incorporate that kind of listening into our ethics. But there are ways in which we can think about doing that in our legal discourse as well as our legal decision making as well. We can also see work toward practical arrangements to incorporate listening to animals within political frameworks. So moving beyond just thinking about ethics, for example. Donaldson and Kimlicka obviously have provided us with their classic account of how we can do this in Zoopolis, where they argue for treating animals as co-citizens, temporary visitors, or residents of their own political communities. So we have work here thinking about how this could be done. And what we're looking to do is to try and start to apply this work to come up with a more concrete vision of multi-species governance for the Anthropocene. Okay, moving on then to thinking about agential force. So if we've listened to animals, what do we then do with the information gained from that listening? Who can act on that information? We think that listening to animals should take place in a legal and political context in which their agency is recognized. We're interested in recent work that moves away from post-Enlightenment overemphasis on individuality and rights as a primary device for socio-political action. Of course, that's a very controversial stance or take in this context, and we certainly recognize the value and utility of rights in this age at this time. But we're also interested in more critical perspectives that are interested in moving away from rights as our dominant or sole tool to improve animals' lives. So as an example here, Anna Greer proposes a shift towards Donna Haraway's symphoesis and concepts of making with, which is all about interconnection of different individuals. The question here is whether it's detrimental for animals if they're just coming into their own legal agency through animal rights, is it detrimental to then move away from this model to think about something else? That would be the question for this forum. Potentially, we could answer no, and we could say that Greer's idea is about imploding or deconstructing the concept of agency, giving wider access to it, and decentering the human in considerations of agency. Non-human animals would undoubtedly benefit from this, so there's potential value to be explored there. Given this, we grew curious about how a more dispersed model of agency could be actioned in our political and legal systems. And we decided to explore, Bruno Latour's concept of hybrids, emerging from his actor network theory as a way in which to action this. This concept of hybrids emerging from actor network theory regards agency as located within alliances rather than individuals. So that speaks to the interconnectivity or the networked way of thinking about governance that I was speaking about earlier. This could allow us to expand our imaginations beyond speaking on behalf of animals. We could evolve to actually allow animals to represent their own interests through these hybrids. And this could look like human-animal collaborations in lawmaking. And clearly, while the exact shape of this remains to be determined in this context, I think this idea of these collaborations or hybrids provides some inspiration for thinking beyond our idea of animal individuals and how animal individuals interact with legal spaces and legal forums and lawmaking processes. Okay, so interesting concept. There are some concerns about how this could be actioned in practice that have been voiced in different pieces of research. So Ariel Saleh warns that this use of hybrids would still have to work to avoid slipping into ventriloquism. Ventriloquism being this thing that we're used to of humans speaking on behalf of animals. It's not inevitable that by working towards a hybrid kind of solution that we would see animals speaking for themselves. There would have to be procedural work to ensure that that would happen. Additionally, we would have to grow comfortable with the idea of seeing human agency operating through these hybrids as well. And that's maybe a big, rather contentious one here. We can't just use these hybrids as an approach for non-human animals, or it would defeat the entire purpose and would further marginalize animals. So that's something to consider, and one of the many considerations we've raised regarding how these sorts of solutions could be implemented in practice. To conclude then, of this whistle-stop tour around our scoping research on multi-species boundaries and multi-species governance for the Anthropocene, we argue that our policy and legal spaces, actors and systems must listen to animals and identify their agential force to tackle dual considerations of network interconnectivity and animal individuals within the Anthropocene. And these issues have not been resolved to date through animal or environmental law scholarship, hence our effort to bring the two into conversation with one another. We think it's worthwhile to think about elaborating upon work on planetary justice that exists already. And at this stage, our contribution to thinking on multi-species governance is pretty modest and preliminary, and we're really at the scoping stages of our investigation here. So we're very open to any and all comments or interest in this sort of investigation. We're hoping to continue rethinking the role of law, responsibility, and agency by deconstructing legal subjectivity, as well as legal operability and legal cosmoecology. Not least among the questions that remains would be, what do we do with the information gleaned from this deep listening, engaged with through new models of agency, and what kinds of multi-species law might result from this? I am very open to having anyone who is listening drop me an email to have a discussion about this. I would love to hear your ideas. Thank you for listening.